All right, so as we come back together and remember to hit record, again, a reminder that we're moving a little ahead of schedule as we move into our discussion of basic farm succession tools. That means that I think what we're going to do is call an audible and talk a little bit deeper about tools than what we usually get to do in this program. So the slideshow that you're going to see is going to look a little different since I'm pulling from a different presentation, but it'll be the same sort of content. So let me get that pulled up for you. And like I said, instead of our a little bit broader overview, we're going to do our deep dive version of farm succession tools over the next half hour or so. So what does that mean? We're going to sort of pull our brains back to that first hour where we talked about intestacy, probate, estate tax, and long-term care. And as I told you, one of the things that I like to do when we think about this is I think about those 4 default settings as our problems. And then as we start trying to adjust the problems and pick tools to fix them, we really want to think about what is it that we're changing and what are the consequences of that. So if our goal is to change one or more of those default rules, what we're changing is the method of transfer. We might be changing the type of transfer. Is it a sale? Is it a gift? Is that gift or that sale occurring at death, or is it happening during life? Is it all at once, or is it in installments? Are we separating and some assets are transferring one way and some assets are transferring another way? We might be changing the recipient. And then as we change those transfers, we also want to think about what are some of the retained rights or the obligations that we have depending on the tool that we pick. So what I'm going to do as we go through tools is, again, always let's relate back to our defaults. Let's think about what it is we're changing. So in the first slide here, you're going to see intestacy, that first default setting that we talked about. Those transfers happen at death. State law determines who your recipient is. And as far as your retained rights, well, you own those assets until you pass away, which means they're available for you to use. You retain all of the rights. You still have to go through probate. The assets are going to be included in your estate for tax purposes. And the court, with maybe some guidance from your beneficiaries, are going to select and appoint your personal representative. So let's talk about how we change that. A very basic tool that we might use is a will. You might have heard this referred to as a last will and testament. Well, what does a will change? It's not going to change our schedule because a will is still not transferring any of those assets until we pass away. But this time we get to pick the recipient. So it's a changing intestate distribution. As far as retained rights, we still have access to those assets until we pass away, and they're still available to us for you to use. We can change our mind right up until the moment that we pass away. As far as obligations, one common misconception, a will is not going to avoid probate. So that will changed intestacy for us, but we still have to go through probate. Those assets are still included in our estate for tax purposes, but you get to choose your personal representative when you're drafting that will. So again, we want to kind of see which default settings we don't like. And then as we're choosing tools, we're going to choose tools that change those default settings we don't like. Now, I will say, keep in mind, almost every plan is still going to include a will, because it acts as sort of a backstop. So that, for example, if we put a trust into place, but not all of our assets end up in the trust, we still have the will as a backup that's going to help direct assets. That's one example of a transfer. A second type of transfer is going to be a statutory non-probate transfer. Now think of like the payable on death or the beneficiary designation that we talked about earlier. That's one example of a statutory non-probate transfer. These are tools that the state legislature has put into our law and said, hey, if you use this process or this method, then the asset that it relates to is going to avoid probate. So what's going to happen here? The transfer is still going to happen upon death. The recipient, you're going to get to choose. So again, we're changing intestacy. Most of these you can still change right up until you pass away, and the asset remains available to use until your death, for example, for long-term care needs. But for a statutory non-probate transfer, we're going to avoid probate. So we've changed intestacy, we've changed probate. However, these assets are still included in our estate for estate tax purposes. We also want to keep in mind that the beneficiary may have to do some documentation on the back end to help finalize that transfer after your death. Some examples, we already talked about the payable on death or beneficiary designation. For real estate, you might have a transfer on death deed. You might use joint ownership with rights of survivorship. Marital property agreements can also actually be used as a type of non-probate transfer. Wisconsin also recently added a new transfer for farm implements. Haven't seen a lot of use of this yet. There are some quirks that may still need to be worked out, but it's something that is out there that may be available. Technically, it is available, but may be more available to use in the future. One of the big risks of using non-probate transfers is that if your plan changes, you might forget to update them. So that could be as simple as, you put a spouse on as a payable on death designation, or you put an in-law on as a beneficiary, but you end up getting divorced, and you may forget that you need to go back and change that beneficiary. And when you pass away, also the facilitator, whether that's the bank that holds the account, they are still going to follow that designation. Despite the fact that you're divorced, they're going to follow that designation. So sometimes we forget to update those. Other things that can happen here, if we are transferring some assets via non-statutory non-probate transfer and others via another plan, that can cause conflicts because, for example, let's say that we are transferring all of our liquid cash accounts, all of our bank accounts with payable on death or beneficiary designations, but we transfer everything else through the probate process. There may be creditors that need to be paid off during the probate process for things like land and farm equipment. But if we've already transferred all of the liquid cash accounts, there's no easy way to access those accounts and pull them back to pay off the debt that might be on the equipment or the land. So whenever we are thinking about using a statutory non-probate transfer, you really want to work with your attorney and your accountant to make sure that it's a coordinated effort with your entire plan, and that as you're updating your plan, you're checking to make sure that you have updated those beneficiary designations if you need to. A third tool for transfer might be a gift. So I'm going to differentiate this from our will or intestacy, as these are going to be our lifetime gifts. So again, we're changing the schedule here. It's going to happen during lifetime, and we're changing the recipient. Again, we're getting to choose rather than being told by state law who's going to receive these assets. Now, once you've given that gift, you don't have retained rights. So if I give Joy $50,000, but next week I realize that I'm actually going to need that to pay for my long-term care, I can't force her to give it back to me because I already gifted it. And again, thinking about our unified estate and gift tax credit, if I gave Joy $50,000 thinking that I wouldn't need it, $19,000 of that was my annual exemption, but the other, let me do some math, $31,000 went against and counted against my unified estate and gift tax credit. Now, if I expect her to give that back to me, the same thing is going to apply. She'll use a $19,000 estate and gift tax credit or annual exemption, but that other $31,000 coming back to me is going to count against her unified estate and gift tax credit. So we want to be very thoughtful if we are using a gifting strategy. The positive, perhaps, or the change is that we aren't going through probate with an asset if we've gifted that asset. So a gift is going to change intestacy. it's changing probate, it is potentially going to impact our estate and gift tax credit if it's over that annual exemption. And again, we're not going to have it available for long-term needs. Granted, there may be scenarios where if you're trying to qualify for Medicaid, gifting assets out of your name so that you can qualify, and then waiting out the 5-year period can be a strategy that works. Now, again, we talked about this earlier. Tax basis is often a consideration, again, just because we've seen such rapid appreciation in our farmland values. But what I want you to keep in mind is that tax basis is really only going to matter when you're selling the asset. So I used the example earlier of the individual whose father bought land at $3 an acre. Today it's worth $10,000 an acre. So if dad, who owns the land, sells that land, we're going to take the price, $10,000 minus the basis, $3, come up with $9,997 times that tax rate, that capital gains tax rate, because he's held it for so long. And that's going to be the tax that's due. If he doesn't sell it, there's no tax due. If dad dies and the asset transfers to son via the estate tax process and it qualifies under the exemption, that step up in basis is still going to apply. So son is going to have the step up in basis to fair market value and could sell that land tomorrow with no tax consequences. But if dad gifts that land to son during life, son now has that same $3 basis, which means that if he sells it tomorrow, he's got the same tax consequence that dad would have. So we do want to keep that in mind. Intestacy, wills, and statutory non-probate transfers typically are going to get that step up in basis. A gift, you're going to have a transferred basis. So those options were all transfer mechanisms where we didn't see any returned value to our current owner. But what if our current owners need some more income generating assets? Maybe they know that they're going to need some dollars out of that in order to pay for long-term care. Maybe they just want to see that that successor really is working for the assets, or feeling that they're okay to gift part of them, but they want to see the cash flow generation paying for another part of them, perhaps to provide some inheritance assets for off-farm children or heirs. Or maybe you're just in a scenario where the successors aren't related to you and you're not looking to give a gift to strangers. What if we need some dollars back? Sales. What do sales look like? So let's talk about just a few. And I'm not going to get into a lot of details about sales, but I want you to see where the difference is compared to our estate planning defaults of intestacy, probate, estate tax, and long-term care. Now, when we make a sale, we're just exchanging that asset, right? So instead of having perhaps a piece of farmland, now we have liquid dollars in our bank account that either are providing for us to have some long-term care or providing for a lifestyle that we're interested in. But again, thinking about, we're still transferring an asset when we pass away. So those estate tax defaults don't necessarily go away, but it has moved the farm from one owner to another at a different point in our life. So when we think about sales, whether it's an outright sale, an installment sale, or a land contract or seller financing, that schedule is going to happen. If it's an outright sale at the time of closing, it's kind of a one and done. If we're closing on Friday, we're transferring that day of. If it's an installment sale or a land contract, we might be transferring portions over a period of time, whether that is monthly, annually, biannually, you name it. You're going to have to work buyer and seller to find agreement about what that schedule looks like, as well as whether all assets are lumped into one sale or whether we have multiple sales that are perhaps closing at different times. In all of these scenarios, we've changed intestacy a little bit for these particular assets because our buyer and seller both have to agree to this transfer. Now let's talk about retained rights and obligations. With our outright sale, you're typically not retaining rights to that property. Now, you might retain a life estate, for example, so you might accept a reduced price so that you can take a life estate and remain on that property in a house or something like that until you are unable to be there anymore and until you pass away. That being said, in most outright sales, we don't see that. That also means that your obligations are typically going to stop or go away at that closing date. So once it's transferred, it's out of your hands. It's not yours to deal with anymore. That being said, if it's an unrelated party, you might have some continuing indemnification rights. And what that means is, let's say that you had a manure pit on your farm operation and it was grandfathered in for a number of years, wasn't up to code, and the next generation is doing nothing with livestock. They've never used the manure pit, but it comes out that there was a leak stemming from that old manure pit. You could potentially have a situation where the new owner has included a provision in the sale where they can point to the old owner and say, hey, I didn't do that. You need to pay for that issue. So we always just want to be thoughtful about if there are any of those continuing obligations for indemnification, how long they last, what they might cost, all of those types of issues. Now, when we're talking about an installment sale or a land contract or seller financing, our retained rights are a little bit different. So with an installment sale, those are typically all similar to the outright sale. Typically, we don't retain any rights there. It's just as it's agreed to. With a land contract and seller financing, the seller technically holds the legal title to the property until they're paid in full. Excuse me. Yes. The buyer is going to hold all of the rights to use that property, but the seller has technically legal title until all payments are made. That being said, one of the risks here is if there's a default, someone misses a payment or doesn't fulfill an obligation. The standard land contract form in the state of Wisconsin provides that a default can trigger everything, including your equity, to revert to the seller. So that can be dangerous if you are the buyer, right? You potentially lose all of this equity, which just means that if you are signing a land contract and you don't want that to be the case, you may want to make sure that you're drafting that agreement or your attorney is helping you draft that agreement or revise that agreement to avoid that. In both of those scenarios, because it is seller financing or accepting payment over a period of time, there also is a credit risk for the seller. Is that buyer going to be able to continue to pay? And this is twofold. So there are scenarios where the farm economy hits and does what the farm economy does, which is be volatile. And financials are no longer there to support that farm operation. And buyer and seller have to think carefully about what would they do in that situation. So sometimes we see family situations. There's a family that I've worked with who said, hey, I've told mom and dad, I just can't make these payments anymore. I need to either refinance this, stretch it out over a different term, and they don't seem like they're hearing me. What can I do? And unfortunately, the answer is you have to either find an agreement and have that conversation, or you are tied to that agreement. So it's important for both sides to think carefully about what can the farm really cash flow. Again, I talked about earlier how important it is to understand what the current owner's budgetary needs are, the future owner's budgetary needs are, and what the farm's needs are financially. But we can really evaluate whether that farm and any off-farm income of the future generation can really support a sale, and whether those dollars are still providing an adequate income for our retiring or outgoing generation. Of course, we do also have tax consequences with sales. The upside with sales is that you are going to have, as a buyer, new basis at the price that is paid. The downside is that there is going to be some tax due. So, for example, with our outright sale, your tax as a seller is going to be due in the year of the sale. If you're looking at an installment sale or a land contract, that tax is going to be due in the years that the payments are received. However, any depreciation recapture income tax is due in year one. So for example, if you have a tractor that you have depreciated out to zero, and now we are recapturing that income because we've sold it, all of that depreciation recapture has to be recognized. Depreciation recapture income has to be recognized in year one, even if the rest of the tax can be spread out. So this is where structure becomes very important. Again, I like to think about first, what are the 4 defaults? What are we trying to change? Is it intestacy, probate, estate tax, or long-term care that is a problem for us and we're trying to fix? Then I start thinking about what are the financial needs? What does cash flow look like for that farm, the outgoing generation, and the incoming generation? What flexibility do we have to work with to decide between a gift or a inheritance as opposed to a sale? Do we need dollars back out of those assets? Ooh, and since well, let's actually go through that. Since we called an audible, I have to sort of remind myself which slides are in here entirely. But as you're just making these decisions, the other thing we have to think about is how we are informing the other generation's decision-making about their own lives. So I'm going to give a quick story about the importance of written agreements, especially when we were talking about a sale. So this was an unpublished case that happened here in the state of Wisconsin. It was decided in 2023. What unpublished means is that the case is available, attorneys can find it and sort of see the facts and what happened, but it's not binding on anyone else. So it's not changing the law in any way, but I like to use it because it's an example of when things can go wrong. And if you by chance recognize these names or folks, please just know it's not to embarrass anyone or to say they did it wrong. We are grateful for the fact that this case happened so that we can use it as a learning experience. So in this case, Estate of Fargan v. Fargan, mom and dad owned a 180-acre dairy farm, and son and his wife came back to the farm to help operate it. And dad promised that he would sell the farm to son and wife, and they started making payments to mom and dad. But as far as putting the agreement in writing, the son said, quote, they would never do it. They'd just sit back and say their word was good. I'm sure we can relate to that in many of our farm situations. But it turns out mom wasn't tracking the payments that were made by son and wife, and it sounds like son and wife weren't either. But dad said, don't worry about it. I'll leave you the farm in my will. But that's not what happened. His will left everything to mom. Before dad died, mom said she would make sure that son got the farm. But after dad's death, mom said she didn't intend to leave son the farm because, well, the other kids wanted it and she wanted them to have it. So about the same time, son talked to an attorney about pursuing his claim to the farm, but he decided not to because, quote, where I come from, you don't sue your 80-year-old mother. Mom passed away about 6 years later and left son 15 acres. About a year later, son filed a claim against mom's estate to enforce the oral contract to sell the farm. And the court said, nope, you waited too long and you didn't tell mom that you were going to sue, even though you knew about this claim. And so you can't bring it now after she's passed away. So again, this is not to embarrass this particular farm in any way, shape, or form. It's just to show the importance of documentation. Things can change over time, and the best way to protect all sides is to document, document, document. Getting back to our regularly scheduled programming, After we have decided, are we interested in a sale for no value, or excuse me, a transfer without value returned, or do we need a sale where we're getting some value back out of this? We also have to think about what I call modifiers, and there are tons of them. You've probably picked up a farm magazine or opened an article on the internet and heard about this new silver bullet that's going to solve all your farm succession problems. And again, the challenge becomes we need to know what we're trying to fix or what we're trying to do before we start selecting tools. So there are lots of tools out there that can do some really great things in our farm succession plans, but we need to know what it is that we're trying to do or avoid or fix before we start picking them. So let's just get a flavor of what's out there. We can do things like transfer restrictions. So we talked a little bit about retaining a life estate, which would allow us to transfer ownership of property while still retaining some rights to live there for the remainder of our lifetime. Alternatively, we could think about just a right of first offer or a right of first refusal, saying that, when this does transfer, so-and-so is going to have the first chance to buy it or the first chance to lease it. We might think about using some long-term leases to provide access to certain land. We might think about co-ownership. Whenever we're thinking about co-ownership, we do, of course, want to be thoughtful about whether people really want to be in business together and what being in business together means. I always caution folks, if you're thinking about co-ownership, you're really getting into a business marriage. And are you ready to be married to this person? And if you're not, or if you have some hesitancies, or even if you don't, just like folks might say, hey, think about a prenup, you want to think about some co-ownership agreements as you're going into a co-ownership situation, sort of that business prenup. It might be an operating agreement with an LLC. It might be articles and bylaws with a corporation. It might be a partnership agreement. But you want to think about, how are we going to work together? Who's going to make decisions? And what happens when we're no longer happy working together? How are we going to get back out of this? Now, if we're thinking about valuation issues, for example, there are different valuation modifiers for different purposes. So for example, if we have an estate tax issue, we might be looking at Code Section 2032A, which is a special use valuation for farmland only for estate tax purposes. So it's only going to reduce the value by up to $750,000, which again, in the grand scheme of what the estate tax exemption is today and what farmland is worth today, some folks will argue that's not very much. I can't say I disagree with them, but the reality is, if you are on that tipping point or you're combining it with other tools, that might be a tool that's a good use for you. The downside of it is fairly strict. It does require some agreements to continue farming that land for 10 years. And if the beneficiary fails to do so for that 10 years, the government may come back, or I should say the Internal Revenue Service may come back and impose that estate tax later. So cautionary tales there. It's got a great purpose. It is fairly strict. If we're looking at a discounted valuation because we're trying to make a sale of some of the property and we recognize that farms are very expensive, we might look at a lack of control discount or a lack of marketability discount if we've put the property into an entity. We might use a conservation easement to either reduce the value of the property for estate tax purposes. We might use a conservation easement to generate some income on the front end, while still maintaining ownership of the property down the road. We also might just choose a conservation easement because it's something that appeals to personal values, and that's totally acceptable too. We might think about charitable deductions if we are in a position where we're trying to reduce our gross estate for estate tax purposes. But again, the key that I want to think about when we're talking about discounted valuations is those are all good tools. And there are more tools out there, but we really want to be clear about what is it we're trying to do. Because for example, let's say that the only reason we're choosing a conservation easement is to reduce the value of the property for estate tax purposes. but we don't have an estate tax problem. Well, then it's maybe not a great tool if that's not something that we feel very strongly about, and we don't have an estate tax problem and we're not trying to generate income. The question might be, why are we using it? And the same thing could be said of the charitable deduction. If someone doesn't have a moral decision that they've decided that they want to donate to something, again, for whatever reason, are we going to use that to reduce our estate tax due if we didn't have estate tax due in the first place? We want to make sure we're doing it because it aligns with our goals and not using a tool to fix a problem that doesn't exist. Again, that friendly reminder of why we start with intestacy, probate, estate tax, and long-term care. We also can talk briefly about entities and trusts. I'm actually going to jump to life insurance first, and then I'll come back up to entities and trusts. Life insurance can be a tool to perhaps provide some additional income or assets to an off-farm heir. Alternatively, you might also use them to provide an on-farm heir with funding to buy out an off-farm heir. Getting a little nitpicky there, we'd have to really lay out specific situations, but just know that it is an opportunity to potentially provide some added liquidity. It also can be helpful in a co-ownership situation if we're concerned, for example, that we have two children that are going to inherit the farm together, but we have concerns about the health of one of them, and we know that the other child may not be able to buy out the unhealthy child if something happens to them and their spouse and family are looking for dollars. We might consider putting life insurance, having cross policies on each co-owner so that if something happens to one, the other has this funding to be able to buy out the family of that individual. That, of course, actually sort of filters right into thinking about entities and trusts. So that can be one way to sort of formalize that co-ownership by using an entity. Within an entity, we can put on transfer restrictions, we can set the terms of co-ownership and how decision-making happens. We can talk about buyout provisions. We can even include things about what type of life insurance we might need to hold. We can talk about ownership with spouses. Basically, there's a lot that we can do with entities. And again, we mentioned before, we might be able to do some discounted valuations there. But again, it all goes back to what are you as a farm and a family trying to accomplish? What are the defaults we don't like? What is the transfer state we're trying to get to? And does that particular plan help us get there? And then I'm going to talk just briefly about trusts. What I want you to know about trusts is that there are many, many, many different kinds. We have trusts that are created when we pass away called testamentary trusts that are still going to potentially have our assets go through probate to fund the trust. That might be something that is common if we have minor children, for example, and we're trying to ensure that an 18-year-old doesn't receive assets outright. We might have a testamentary trust that is going to appoint a trustee to hold and manage assets until a child turns 18, until a child, quite frankly, you can pick which ages, you can set certain milestones, you can decide what gets released at certain times. You can give that trustee instructions. So for example, if you have a 15 or 16-year-old who you think is very likely to come back to the farm, and you're trying to provide that someone will help, that trustee will help that child manage farm assets until they are 20, 21, 23, you choose your age at which you think they're going to be ready to take over, without as strong of guidance, you can sort of set some of that up. Now, if we've got a 4-year-old and 2-year-old, and we're talking about asking someone to manage assets for 20 years, that gets a little harder. But when you get older minors, there's some leeway there or some opportunity there. We might also have trusts that provide for special needs, folks with special needs. So perhaps allowing them to still qualify for supplemental security income or Medicaid while still having some additional funding from you. via that trust. We also can do things like providing for spouses. So for example, perhaps, or I shouldn't even just say spouses, I'll say partners. Perhaps you have a second spouse or a partner and you have children from a first marriage who are planning to take over the farm. You may want to use a very specific type of trust to provide for that spouse or partner to remain in a home or have access to certain property or certain income for their lifetime, with the remainder reverting over to your own children upon your death. We might use trusts if we're in a situation where we're trying to qualify for Medicaid to move assets out of your name. If we are in a scenario where your net worth is really high and we think we're going to have an estate tax problem, we might look at taking advantage of the current higher estate tax credit by transferring assets into an irrevocable trust this year, taking advantage of that higher exemption before it drops, but recognizing that we might be giving up some control of those assets when we do that. So the short story on trusts is that there are many options. They can do many things. But what you as an individual need to do is to really work hard on understanding those default settings and thinking about your own, again, I'll call it dirty laundry because it's easy to think about that way. But it really is just your unique family dynamics and habits or concerns. Because if you can identify those concerns and share them with an attorney, they're going to be much better suited to help you choose a tool that can potentially address a problem or a concern than if they have no idea that it exists.